Factual background. At the start of Mr. Dow's jury trial in this case, Nevada attorney Anthony Tony Esgro was Mr. Dow's privately retained counsel of choice. Mr. Esgro had appeared on behalf of Mr. Dow throughout the earlier proceedings in this case. However, on the first day of Mr. Dow's jury trial, Mr. Esgro was not present. Instead, Jonathan Powell and Eric Farron, who were associates of Mr. Esgro's firm at the time, appeared on Mr. Dow's behalf. Mr. Powell, on behalf of Mr. Dow, requested a short continuance of the trial because Mr. Esgro was allegedly out of the jurisdiction. Mr. Powell clearly stated on the record that Mr. Esgro was Mr. Dow's counsel of choice. I'm sure you are probably not inclined to do what we're going to request, but we would move that you continue trial to Thursday. The reasoning for that is Mr. Esgro will be returning from town on Thursday. Now, prior to this time, one of the conflicts was he had a medical malpractice trial starting next Monday. However, that case has since been settled, which would allow Mr. Esgro, when he returned, I believe he's returning between Wednesday and Thursday at midnight, would allow him to get up to speed on Thursday. I could do the voir dire Thursday morning on Mr. Farron. That would allow opening statements after lunch, and we could do call witnesses then. The reason why we're asking is we believe that it'll create a better record for if there is need for an appeal, as Mr. Esgro is clearly the choice of Mr. Dow in this case. Emphasis added. The district court responded. The court, okay, well, we're starting today. Anybody that's ready is here, you know. If you wants to join the team in the middle, I don't care. We're dancing today. Mr. Powell, thank you, Your Honor. The court, the motion is denied. ID. Emphasis added. After the trial court denied the request for a brief continuance so that Mr. Esgro could serve as lead counsel, the parties conducted voir dire, and then the state presented its case in chief. The state's theory at trial in this matter was that Mr. Dow entered into a conspiracy with the co-defendant Jason Mathias to lure the two victims to an area wherein the victims were ultimately shot to death. Specifically, the state alleged that the victims were killed in retaliation for the death of a hip-hop musician named Mac Dre, who was previously shot to death in Missouri. 9. The state asserted at trial that Mr. Dow lured the two victims, Mr. Watkins Akafatone and Mr. Akins, to Las Vegas under the guise that they would meet famous hip-hop music star Snoop Dogg, wherein Snoop Dogg would help further Mr. Watkins' music career. According to the state, rather than arrange a meeting with Snoop Dogg, Mr. Dow drove the victims from the MGM Hotel and Casino in Las Vegas to an isolated location near co-defendant Mr. Mathias' residence, wherein both men were shot to death by the defendants. At trial, there was video camera footage of Mr. Dow and the victims walking through the MGM Hotel and Casino to the parking garage. However, there was no video footage which depicted that they all left in the same vehicle. The state also introduced evidence of Mr. Dow's alleged flight after the incident in question, including evidence which allegedly suggested that Mr. Dow fled to Northern California following the shooting, where he later allegedly killed another participant in the Watkins/Akins homicide. Ms. Lee Lawson. The state attempted to corroborate the killing of Ms. Larson through the testimony of criminal defense. One, the state attorneys Marty Hart and Keith Brower. One, Mr. Brower was Mr. Dow's counsel in a previous matter, and over defendant's objection and Mr. Brower's objection, Mr. Tin also called a witness identified as Antoine Mountain, who testified that Mr. Dow indicated in an alleged conversation too that he was involved in the murders. After the state rested, Attorney Powell indicated on the record again that Mr. Dow was requesting that Mr. Esgro be permitted to appear. The court indicated that it would permit Mr. Esgro to appear, albeit in the middle of the trial. However, the court warned Mr. Dow that bringing in another lawyer late could be viewed negatively by the jury. Specifically, the court engaged in the following exchange with the parties. Mr. Powell, today, yes, Mr. Dow has as you know, requested Mr. Esgro at various times during this trial. He is again requesting Mr. Esgro, the court, to do what? Mr. Powell, participate in this trial, and that would be the court. He can. Rob was ordered to testify. See also info. This issue was also not specifically addressed on direct appeal. 2 on December 21, 2021, defendant filed a petition for writ of habeas corpus related to alleged Brady/Giglio violations related to this witness. Said petition raises significant issues which also warrants reversal of Mr. Dow's convictions, including that Mr. Mountain was in custody at the time of an alleged conversation. Mr. Mountain also recanted his prior statements to law enforcement and his testimony. These issues are also subject to a recently filed appeal with the Nevada Supreme Court, and Mr. Dow reserves his rights regarding said petition. 11. Mr. Powell. Yeah, I just want to clear it with your honor that if we all are in agreement that Mr. Esgro come on board and assist, that your honor would have no problem with that. The court, I have no problem. I do not. And I'm not telling you this so you won't do it. But I'll tell you this. I've had one experience in my life where I've seen that happen, and I happen to be the plaintiff's lawyer in a fairly substantial personal injury case, and I got a big award, and then there was a punitive damage phase, and they brought somebody else in along, to sort of shore it up, and the jury took from that their team thought that they were just a host. Their team didn't think they were doing very good and didn't have a very good case, and I got a big punitive damage awarded too. Not saying don't do it. I'm just saying there is a reasonable inference to be drawn to bringing in a relief pitcher in the 8th inning, and sometimes that is, oh shit, our starters are fucking up. We're in trouble. Mr. Powell. Understood, your honor. And I explained that to Mr. Dow, and it's a consideration. The court, well, what I'm saying is I don't care. Mr. Powell. Yeah. The court, you can bring in Bozo the Clown, F. Lee Bailey. You can bring them in. 12 tomorrow. I don't care. Do whatever you want to do. The defendant, I want Esgro to come because he's familiar with the case. It's not like he's a stranger. The court, not a problem. The defendant, if he would have been here earlier, I believe a lot of this shenanigans wouldn't have jumped off. But now the court, you're not getting any quarrel from me. You can have him if you want him, if he's ready. Not a problem. And I think, actually, when I was arguing the case, I mentioned a little something about a relief pitcher and how arrogant it must be of them to think that, you people are so not doing your job that they're going to. Mr. Giacomo, those 7 would never let me get away with that, but I hope Esgro shows up, cause I'll find a different way to stick it to him. The defense then presented its case and called witnesses which established that Mr. Dow was a well-known hip-hop music artist and was motivated to help the alleged victim, Mr. Watkins, a.k.a. Fat Tone, with his music career. The defense also called 2 witnesses, namely Franzen Wang and Joe Tasby, whose testimony suggested that Mr. Dow was at the parking lot of 97.513 radio station from 12 until at least 2 a.m. on the morning of the murders, and not at the crime scene. After putting on most of its defense witnesses, Counsel Powell informed the court that there were timing issues with securing Mr. Dow's additional witnesses, despite counsel for Mr. Dow asking for additional time for witnesses to arrive. The district court refused and only permitted 1 additional witness to testify for Mr. Dow. As stated above, Mr. Dow was ultimately convicted by the jury. After Mr. Dow was convicted, Counsel Jonathan Powell filed a motion for new trial. The motion argued that a new trial was warranted as Mr. Dow was deprived of his counsel of choice, Mr. Esgro. Said motion also set forth that Mr. Dow was not able to call certain witnesses in support of his defense. Specifically, counsel for Mr. Dow provided declarations from witnesses Gary Owens and Darrell Anderson. The declaration from Gary Owens set forth that he had previously met one of the alleged victims in this matter, Anthony Fat Tone Watkins, in San Francisco with Mr. Dow. According to Mr. Owens, He was informed that defense witnesses were supposed to testify on Friday, July 18, 2008 and Monday, July 21, 2008. According to Mr. Owens, based on these representations, he made plans to travel to Las Vegas on July 18, 2008, so that he could testify on Monday, July 21, 2008. However, Judge Bell ultimately changed the defense testimony scheduled to Thursday, July 17, 2008, and Friday, July 18, 2008. When Mr. Owens arrived at 410, the courthouse, the parties had already begun closing arguments and he never testified. Mr. Owens had personal knowledge that Mr. Dow had previously helped to promote Mr. Watkins' music, and that on a previous occasion, Mr. Watkins borrowed the same automobile that he was found killed in, that Mr. Watkins drove this car around San Francisco without defendant being present. Like Mr. Owens, the declaration of Darrell Anderson also set forth important exculpatory testimony that Mr. Dow was not able to present at trial. According to the motion for new trial, Mr. Anderson was originally contacted regarding testifying on Monday, as he had work engagements and it would have been difficult for him to be present on Friday. After he confirmed his ability to come on Monday, and after defendant was told to have his witnesses available by Friday morning at the latest, defendant attempted to contact Mr. Anderson to have him come in earlier on Friday. But defendant was not able to reach him on such short notice. When defendant did finally contact him in the middle of the week, it was already too late for him to change his employment responsibilities. It was not possible for Mr. Anderson to arrive on Friday at all to testify. Mr. Anderson would have testified to the following: that he had a long-standing professional relationship with Mr. Watkins, that he seen sick Mr. Watkins driving the automobile he was found dead in around Las Vegas. 15, without defendant, that Mr. Watkins reached out through Mr. Anderson to contact defendant in order to allow them to do music together, that there were a number of individuals looking for Mr. Watkins, possibly to do him harm, and defendant was not one of them, that he spoke to Mr. Watkins while he was in Las Vegas, shortly before he was killed, and Mr. Watkins was attempting to arrange studio time for him and defendant in Mr. Anderson's studio. The motion for new trial additionally stated in part, these witnesses' testimony would have been crucial during trial. No other witness could testify that Mr. Watkins was in San Francisco with Mr. Dow after the McDree killing, the one place he was supposed to be in the most danger. No other witness could testify to other individuals looking for Mr. Watkins, potentially to harm him. No other witness could testify that it was Mr. Watkins that reached out to defendant in order for their musical collaboration to start, not the other way around. No other witness could testify that Mr. Watkins had possession and control of the car he was found dead in wholly apart from defendant, and that it would not have been unusual for Mr. Watkins to have driven the automobile with defendant, because defendant was denied his ability to call witnesses on his own behalf that he had previously subpoenaed. Defendant was denied a proper trial. 16, after Mr. Dow was convicted, he ultimately retained California attorney Stuart Hanlon to handle his direct appeal. Mr. Hanlon utilized Nevada attorney Lisa Rasmussen as local counsel, despite the above issues being raised in Mr. Dow's motion for new trial. These issues were not raised in Mr. Dow's direct appeal. Significantly, after Mr. Dow's trial, Carlos Levixier, a witness who testified for Mr. Dow at his sentencing phase, spoke to one of Mr. Dow's trial attorneys, Eric Farron, who stated to the effect that Mr. Dow's attorneys would fall on the sword in Mr. Dow's post-conviction matters. Mr. Farron indicated to Mr. Levixier on the last day of Mr. Dow's trial after Mr. Dow was sentenced that another firm should argue ineffective assistance counsel in post-conviction matters because Mr. S. Grove was not Mr. Dow's counsel at trial, and S. Grove's absence amounted to ineffective assistance of counsel for Mr. Dow at trial. According to Mr. Levixier, There were other witnesses to the conversation. Notably, when undersigned counsel attempted to ask Mr. Levixier about this conversation during the evidentiary hearing on March 17, 2021, the state objected and undersigned counsel was prohibited by the district court from doing so. At the evidentiary hearing on March 17, 2021, Mr. Finnegan admitted that he was not a licensed attorney. In addition to hiring counsel to file the direct appeal, Mr. Dow, through his agents, Matthew Matchon, 17, as well as Mr. Levixier, also paid to have a post-conviction petition filed on Mr. Dow's behalf. During the evidentiary hearing on March 17, 2021, Mr. Finnegan admitted that he informed Mr. Dow and his agents that the clock stopped for the time to file a post-conviction petition. Specifically, Mr. Finnegan testified in part, Q, and did you told them that as long as you were investigating the clock would stop, correct? Yeah, I think the way I probably phrased it was as long as we were exercising due diligence and discovering new evidence that it would toll the period. Yes. Emphasis added. Mr. Finnegan also testified in part, Q. But my question is this. You're saying that there was apparently some decision to forego filing in the Nevada State Court, but then you're telling Mr. Dow and Mr. Matchon, knowing they're relaying the information to him as well, saying, well, first we have to file in state court. So if you were aware that there's a 1-year deadline, and then you're also telling them the clock stopped while investigating, don't you understand how? You understand there would be confusion here. Yeah, I don't doubt that the whole habeas deadline law was confusing. 18Q. And then I'm just going to show you Exhibit 67. You had previously given a. You were also interviewed during the bar investigation process by the California Bar. Correct? A, by an investigator. Yes, Q. And then you let me ask it this way. Did you ever tell Andre Dow at any point in time that the habeas would not be filed by you or Mr. Hanlon? A, it would not be filed. Q, did you ever say to Andre, we're not filing a petition for you? A, no. Emphasis added. Moreover, on July 19, 2010, after Mr. Dow questioned Mr. Hanlon about the status of his post-conviction petition, Mr. Hanlon wrote a letter to Mr. Dow which stated as follows, I have been in trial for 6 weeks. I have not been around at all. Equally as important is that Tim is doing this writ and habeas corpus and not me. I have agreed to be involved if it goes to oral argument, but I'm not working on the habeas. Therefore, I'm forwarding your letter to him. I hope there was no misunderstanding on what my involvement with SIC be regarding this, but the money was 19 for him and not me. He is in charge of this. I never told you that I would come out to see you. I'm not trying to be difficult, but this is how we set up the appeal work. Again, I'm forwarding your letter to Tim. Emphasis added. Notwithstanding these representations, no petition would be filed by Mr. Hanlon or Mr. Finnegan. On at least one occasion, Mr. Hanlon even sent a text message to Mr. Matchon which stated in part that Tim is Mr. Dow's lawyer. Mr. Hanlon also wrote to Mr. Matchon that as you know all money you paid went to Tim and the investigator. ID. During the evidentiary hearing on March 17, 2021, Stuart Hanlon testified in part, A. So it looks like Tim got all the money. But he didn't. He got all the money that they eventually paid. And there was video interference to pay anybody else. Q. Now, when you do the appeal work, have you done post-conviction risk with Mr. Finnegan? A. Have I done? I'm trying to remember. I don't know if I've done risk with him. I've done risk with other people. But I don't know if I've done risk with him. I can't remember. 20Q. Okay. Now, when you, for example, in this specific case, Mr. Finnegan was sick then, turn to Mr. Dow to speak with him about his case. Is that correct? A. Say again. He what? I'm sorry. Q. When you brought on Tim Finnegan to work on the appeal, you introduced him to Mr. Dow to speak with him, correct? Yes. Because, there was a reason why. But yes. Q. What was the reason? The reason is that Mac, Mr. Dow, would call all the time. He was writing and calling all the time, and I needed someone to deal with him on a basis besides me because I didn't have the time. So I introduced to him Tim, who was working on it, but also would be a buffer between me and Mr. Dow. I'm going to tell you the truth, because it was hard to take the calls and read the letters, all of which I read. And I got calls daily from Mr. Dow, and Tim was a buffer in a sense. Q, and you testified. That's the Q, sorry. Go ahead. No. That's go ahead. 21Q. And you testified, so you specifically did not inform clients that Mr. Finnegan was not an attorney, correct? No. I didn't inform them of that. Q. Okay. In fact, you actually told people that Mr. Finnegan was an attorney, correct? Well, I think I told Mr. Dow that for reasons again. The same reason. I wanted Mr. Dow to deal with him. And I think looking back at the letters that I sent you, it was a mistake I made. I shouldn't have said that Tim was a lawyer when I knew he wasn't. But I just needed a buffer between Mr. Dow and myself. And Tim did that. And I said those things. But I knew Tim wasn't a lawyer. And I never represented to any court that he was a lawyer. But I did represent it to Mr. Dow. Emphasis added. After Mr. Dow and his agents continued to try and reach Mr. Finnegan and Mr. Hanlon, to no avail, Mr. Dow was forced to file his first post-conviction petition, improper person, on April 20, 2015. That petition was initially denied by the district court and was remanded for an evidentiary hearing in the Nevada Court of Appeals order filed on June 11, 2019. As stated above, after the evidentiary hearing on March 17, 2021, the district court heard argument 22, found good cause for the filing of the petition in 2015, but denied an evidentiary hearing related to prejudice, and ultimately denied Mr. Dow's petition.